Hi everyone. So what we'll do, we're bang on 2 o'clock now, so we'll wait a couple of minutes just to see who else filters in. I know there's close to 50 people had subscribed, so to say, to join. So I'll give it a minute or so. But just for kind of general housekeeping, as we did before, we're going to record the session. So that's just to make sure that it's available for anyone else who couldn't make it, and we can reuse the training sessions again and again. For those who I haven't met yet, so my name is Kyle Wright. I'm a lawyer. I have a consultancy called Outhouse Legal and Art Consult, and I used to previously be employed by Lamprell and Ensco/Valaris many years ago as well. So throughout my career, I've basically spent my days navigating exactly what we're going to cover today. So that's the quick intro. Yeah, so again, as I say, there should be close to 50 people. If they make it, they make it. Just to make sure we kind of cover everything, if you have any questions, drop it into the Teams chat as they come to mind, so you don't forget the points you're looking for. We might have, if we have time, we'll have a designated Q&A session at the end, or we'll try and at least build it in between sections and open the chat and see what we can address, kind of the quick wins, and hopefully we'll have a good discussion. So can everyone see the slides? Slide singular. See the slide in front? Just drop a quick yes or a thumbs up, or however you want to communicate. Blink once for yes, twice for no, etc. Cool. Excellent. Okay, again, same as last time. We are after lunch. For those of you who are in the UAE and then generally the GCC, just drop 2 words into the chat just on how you feel. Get your fingers going. So there's 2 words that describes how you feel right now. Might be tired, might be happy, might be sad because England lost yesterday. Sorry to bring that up. Totally necessary. Yeah, drop in the chat any 2 words, just to make sure everyone's alive and not subject to AI or whatnot. Brandon's jet lagged. Key to fighting jet lag: as soon as you land, hit the gym. Fight through. Sophia, curious about the session? Cool. We'll satisfy that curiosity urge once we get started. Scottish happy. Excellent. Okay. So just to get started, so this is the slide you got in front now. It's just a quick intro on the contracts work group. I don't know who's fully aware of what we do, what we cover, and so on. And we kind of do try and follow the IADC's general kind of mandate. We try to make sure we share knowledge, we help each other grow, we strengthen, and so on. So we do that generally by, say, collaboration, knowledge sharing. There's some tendering excellence in there, looking at best practices, and also see how we can use AI and bring innovation. So my fundamental role as the chairperson for the group is to help drive that agenda. Okay. So for those who want to maybe join the work group, right now we have myself and Amira. Amira unfortunately couldn't make it today. She is traveling as a last minute emergency. But there's the QR code. It'll take you to a landing page. Jump on the landing page and you can sign up or show your interest as well. And again, you don't necessarily have to be a lawyer. You don't have to be a contracts manager. You could just be, you could be a procurement professional just looking to get more information and also generally to contribute to the group. and see where we land with it. Okay. Okay, so getting stuck in. So this is the second session that we've had in the training series. For those who were here before, we covered the structure of a contract, which sounds very elementary and so on, but it did open a lot of eyes for a lot of people. There's a good bit of dilation. So this is your first session. We can definitely send you the slides from the last time. So this session is going to be different in an important way. It's not just looking at what can go wrong. It's also looking at then how the protective clauses actually work, and the engineering of that protection itself. And we're going to look at liability, we'll look at indemnity, and we will look at termination, and what they're designed to achieve, how they achieve it technically, and what makes the difference between a clause that's that generally protects the business, and one that merely looks like it does. It gives that facade or illusion. And a lot of clauses, as you all probably are aware, the devil's in the detail. And then maybe if we have time, we'll close off with a case study, just looking at a poorly drafted protection package, and then that'll kind of pull everything together. If we don't have time, as I say, you'll get the slides afterwards, and you can do that in your own time. A little bit of homework, and if you have any questions on it, you can email me. So, as a general premise, everything that we look at is it's general training. It's going to be based around English law. There will be some UAE nuances and some Saudi nuances when you look at like the Civil Transaction Code and good faith and goodwill and so on. None of this is going to be like a template or legal advice per se as well for any specific contract. So as you say, we'll look at things generically. And if you need any further assistance, by all means, you can email me afterwards. So there we go. So basically, 7 main points, main areas. We'll start with the kind of protection framework there in top left. We'll look at these 3 clauses, see what we're trying to achieve and how we bring them all together. We'll then look at the mechanics in detail, how liability arises, how it's allocated, how indemnity clauses work from a technical perspective. We got the mutual hold harmless regime. I actually, my off topic but on topic, when I was at law school, my thesis was on a comparative study of the mutual hold harmless scheme against other indemnification schemes for offshore drilling. So I've got a little bit of passion for this in a quasi nerdy way, but you'll forgive me for that. So then we'll spend time, we'll look at termination, number 5 there. On that, we'll look at the mechanism for protecting value and what happens when the contract ends. Because usually there's a lot more that goes into termination. There's usually a deeper termination strategy that looks obviously liabilities, reputation, and so on. We'll just look at the mechanics of the clauses in that. And then we'll cover the kind of core drafting skills, drafting principles. And as I say, if we have time, we will look at the case study. Okay, so jumping in on the protection framework. So to kind of start with that, like a framing point that I think is kind of worth it, because it's going to change how you basically approach or view a contract. So you got liability, you got indemnity, and you got termination, right? And these aren't going to be separate clauses. They sit near each other in the contract, and they're a system. It's a protection architecture. They've been engineered to coexist and function like a very efficient system. And it only works whenever all 3 of those components are actually correctly designed and they're internally consistent. Because if you start having ambiguity and you start having contradictory clauses, that's where it starts to crumble. So any gap or inconsistency in any one of them has the potential to basically undermine the protection that's provided or designed by the other 2 clauses or other 2 elements. So taking left to right, you've got liability. So this is going to be your foundation. This is the root. So this is then going to define what could go wrong. It's going to look at who bears the financial consequence. It allocates the risk between the parties, who pays, how much, and for what categories of damage. And without that well-constructed liability regime and system, the other two clauses don't have a foundation to build on. If you don't know who, where, what, why, when, it's impossible to then look at the indemnity part without having massive gaps, massive holes. So your indemnity section then is going to be the mechanism, okay? And it goes further than the liability allocation. It's going to create a positive obligation. It's going to be where one party is going to step in and hold the other party harmless against the specific losses that are in the contract. And the indemnity is how the theoretical allocation of the liability becomes a practical financial obligation. It puts quantification into those words. And it operates regardless of fault, which is it's what makes it so powerful. So again, keep that in mind. And then you got termination on the right. So that's the exit mechanism, okay? That's going to basically govern how and when the contract ends. It sounds very self-explanatory, but it's critical because it also then determines what each party recovers when the contract does terminate, what rights, what obligations survive. The contract's end. Usually you're going to have your indemnification will survive. There'll be confidentiality will survive, and so on and so on. There's going to be a separate survival clause linked to the termination, which what we said in the last session was you look at the contract holistically and you have to map out, okay, write the word termination down. Where else does this connect? Where are the other touch points in either the operations or the contract itself? And from that, then you pull together all the relevant contract documents that make up the entire agreement. So a poorly drafted termination clause can leave a party basically with no commercial recovery. You could be in a position where you don't get what's owed, and it's financially crippling. And there at the bottom of each of those columns, you've got where the mechanism fails without care. So liability without a cap, your exposure is potentially unlimited, and that will have a position where you could be left at law. And obviously, then depending on the jurisdiction, the courts would look at things differently. What can and what can't be recovered. Without defined consequential loss exclusions, as we say there, a single incident could produce claims that are catastrophic. You could have a claim that could make the business sink if it's not to the right proportion. And again, it also depends on how much time you spend on these clauses, what you look into the clause, how reasonable it would be for a company to look at the magnitude and look at the liabilities. There you got indemnity. So again, without proper group definitions, as we discussed last time, the group definitions, the right fault neutral language, making sure it's very clear on who does what. If you don't have those clarification points, then the indemnity may not cover the scenario that it was designed for. It's a lot of people in the indemnity would have a catch-all and then do the carve-outs rather than say what you are responsible for. You say you're responsible for everything except 1, 2, 3, 4. Well, that's what you would do if you've got the opposing party. You would try and put everything on them with the specific carve-outs rather than the other way, which would leave for gaps. So termination there on the right. Again, with termination, without a specifically drafted recovery position, the party whose contract is terminated for convenience, as an example, may receive only a fraction of what they're owed as well. So again, it's having that clarity from the get-go whenever you're doing the drafting. Okay. So this is a bit heavy on this slide. Apologies. But before we get into the mechanics, this is kind of showing you what we're protecting against. This is the kind of financial exposure spectrum. Be the easiest way to describe it. And the best way to look at it is you're going to go from the bottom up, going from green to red. So at the base, you've got direct financial loss. You get paid. That's going to be your payment disputes, day rate claims, variation arguments. These are things that are resolved by the liability cap and the payment mechanics, and that's usually within an insurance capacity. Both your parties, your insurance coverage, which either your treasury department or whoever manages insurance will be able to give you the exact inclusions and exclusions, what you need to be aware of. Because again, insurance is more of a form of risk transfer. An insurance policy is passing on the risk to a third party, i.e. your insurance company or insurance provider. Then you got property damage. If a rig's damaged, if there's tool loss, equipment failures, these are serious. Don't get me wrong, but again, they're usually within an insurance capacity. You know how much your rig is. You know how much your tools cost. You know how much the equipment is. And if the policy is properly drafted and there's an offshore extension in place, you should be covered. Then you've got third-party personal injury. So again, this is going to be claims by personnel injured during the operations. When we say SP here, it means a service provider. It's significant again, but it's also manageable within the adequate insurance program and how you draft your clauses as well. So then, when you look at the numbers, you got the contract value for direct financial loss. You got 500 to say 5 million quid for property damage. Then you start going a bit red. You get the third party injury, 1 million up to 10 million. It could be more. And then you jump into the unknown, which is your consequential and indirect loss. So that's going to be your loss of profits, loss of contract, loss of opportunity. And these are specifically excluded from a well-drafted mutual hold harmless clause. Because you'd be exposed if you didn't have one. Each party should be burying their own dead per se, but there needs to be certain carve-outs so that there is still skin in the game. There needs to be a level of accountability and a level of responsibility that needs to be attributed to the clauses. Okay. Loss of production, there, one from the top. Again, guesstimates. But you look at the North Sea, a single day for an unplanned rig downtime for a service provider could cost the operator 250 up to 500k a day in lost production revenue. So when you start thinking of actual numbers, it starts to get quite high. And if you look at that and say, okay, over a week of downtime, that figure is going to go up into the millions. And without that consequential loss exclusion that explicitly covers production revenue, you've got a living, breathing, live exposure that you don't want to be subject to. And then there at the very top, you've got the reservoir and well damage, loss of reservoir production, cost of sidetrack, plugging, abandonment of a well, etc. that's been damaged. And these figures can run into tens of millions. You just would not know unless you were a well economist. And these are typically uninsured, or if they are insured, they're heavily underinsured. Because again, insurance, well, first of all, insurance is a choice, unless it's a contractual obligation. There will be marginal statutory requirements for insurance, but the limit or the cap, it's up to yourselves or your companies if they decide they want to go above that cap. And they are, without question, existential risks for a service company or a service provider. And the line, let's start at the bottom. We've got a well-drafted protection package. You're going to have liability, indemnity, and termination. And having all three of those, you've got a better chance of closing the exposure at every level of this spectrum. And you can use this as a takeaway, as a guide sheet as well. And that's what we're going to be looking at in this whole session, each of those respective clauses. Coffee. Okay, so how liability arises. So again, starting with the mechanics of how contractual liability arises under English law, as we said, we'll be gearing around that. There is a chain, and again, I'm sure everyone who's done kind of contracts 101 will be aware of say torts and contractual claims. So each contract can intercept each of our clauses at each stage. So step one, the standard breach of contract. So there must be a failure to perform a contractual obligation. It's a must. Failure to mobilize by an agreed date. It could be delivery of non-conforming services, failure to pay an invoice. And again, if there's no breach, there's no liability. It's very simple. And that's why, like force majeure clauses, hardship provisions, and certain conditions precedent matter, because they can prevent the breach from arising at all by excluding or excusing that non-performance, or making it an obligation and conditional. Per se. Step 2 there, you got causation. There needs to be a breach that that caused the loss. The breach must have caused that loss. So again, it sounds very obvious, but it matters. So if the service provider's equipment fails, but the rig was already on standby for an unrelated reason, for example, the equipment failure might not have actually caused the loss of production. So consider that. You got to look at the wider picture. So whenever a court would look at the chain of causation, they look at it very, very carefully. They'll look at intervening clauses. They'll look at a third party's independent act. They'll look at the claimant's subsequent failure, their own failure, I should say, because that can all break the chain of causation, and that could then also reduce or essentially eliminate the liabilities that are there. Then you got step 3. You got remoteness. This is it's the filter that English law applies to the type of loss. So there was that famous case. It was Hadley and Baxendale, an oldie one from the 1800s, because we know law does move quite quickly. And again, it still remains the controlling authority 170 years later, which basically says only losses that were reasonably foreseeable at the time of the contract are enforceable. Recoverable. I'm thinking about sanctions there, about enforceability, are recoverable. And that's the common law's own consequential loss filter. So the contract's consequential loss exclusion clause, it would replace that test with a defined, more reliable exclusion. Yeah. And then we got step 4, which is quantum, the measurement of the actual loss. So even where the breach or causation and remoteness are all established, the claimant, the one making the claim, must prove that the actual financial loss was suffered. There was an actual financial loss. Speculative losses or unproven losses could either be rejected or could be reduced. And the claimant has that duty to mitigate. You don't just sit back with your hands behind your head and watch the disaster continue. The claimant has that duty to try and reduce or mitigate the loss. And then you got liquidated damages clauses. Yeah, they're agreed figures in advance, and they also do replace that need to prove actual loss with a contractual fixed sum. But then there are times where people would say that they signed that under duress or under pressure, and that they were excessive and so on. So there are times where even if you have a liquidated damage figure, again, a genuine pre-estimate of loss, that could be challenged. So again, always kind of consider that as well. Make sure that the number is reasonable and it's defensible and it's calculatable. So this is the kind of key insight I'd say from this chain, is that the contract can intercept liability at every step, and it's not just at the damage stage. A well-designed protection package would address all 4 links whenever you look at it: who, where, what, why, when, how much. Jumping in a little bit deeper on the consequential loss. So you get direct and consequential loss. In my view, this is probably one of the most important conceptual slides, I would say, that we'll look at. And it's the distinction between direct and consequential loss, because that's going to be what governs the magnitude, essentially, of recoverable damages. Okay. So once you understand that, it will probably change how you view the clause once you get a deeper understanding. So direct loss is that flows naturally and directly from the breach. So the immediate foreseeable financial consequence that we say there. So in this context, oil field, it's going to be the cost of remedying a non-conforming service. It's going to be the additional higher cost for replacement equipment. It's going to be the price paid for services not delivered, and so on and so on. So these are direct losses, and they're recoverable under English law. On the right there, we've got consequential loss. This is going to be what arises from the special circumstances of the claimant, and it's not from the breach. Okay, it's something that is the knock-on. So, from the context, it's viewed from the context in which it occurs. So, in this case, loss of oil production revenue during downtime. There's a big one, especially for the operator. The loss of value or valuable flow-on contracts, the loss of profit on the overall project, reservoir damage, it gets quite big. And under English common law system, the consequential losses are only recoverable where the defendant had knowledge of them at the time of contracting. So if the service provider didn't know the operator was relying on them for a specific production target, the operator can't claim lost production against them. So again, the threshold for proof and the threshold for the burden of evidence or the burden of proof is quite high. You can't just walk in, throw down a claim and demand. You've got to be able to justify it and defend it, and again, really be open to scrutiny on it. I think here the bigger kind of problem for oil field contracting is, again, the common law test is generally uncertain. A court could characterize production losses as direct, especially in the context of an oil field kind of services contract, where the loss of production is, it's obviously foreseeable. You could see that if there's operational failure, that there would be a loss of production. And that kind of shows that the common law test is unreliable because the context is fairly obvious. I think this is why then, the contractual consequential loss exclusion is so important, because it replaces that uncertain common law test. So you have to create your own test and have your own clarity, and contractually agree whatever the exclusions are. A drafting of that exclusion, specific categories listed, that's what determines whether loss of production, loss of profit, reservoir damage, etc., is excluded or not. So there's times where with drafting you think, Jesus, this list is excessive, but again, if it's not in, it's out. And you got to try and take that view on most of these things. So set that in. So again, if we look at the bottom, which I've removed slide. The contractual exclusion of a consequential loss, it's almost always negotiated. I'm sure you've all experienced that, and it's the breadth of this exclusion is what's going to be, say, the variable negotiable part, and that's what matters. Because again, a standard exclusion clause would say something like neither party is liable for indirect and consequential loss. And that uses only the common law formulation. When we look at it from the oil field context, the court, as I say, would look at it with a different vantage, different view. So the clause really needs to get into that nitty gritty of an exhausted. Not you could go for an exhausted list, but also try and include certain catch-alls. Very, very clear. Okay. So jumping on now to liability caps. Liability caps are often very, very hard. Very people don't know what number to put in their liability caps. So taking the view then that the liability cap is it's the ceiling on the financial exposure is the easiest way to put it. And if we kind of start with that statement and say, like, a liability cap set at the contract value is almost always wrong. People don't like that, and it often surprises people as well, because they usually say 100% of the contract value, 110% of the contract value. And the reason it's almost wrong is, say if you have a services subcontract, say it's in the North Sea, it might be worth 150k. So a week of cement, a week cementing program, as an example, if the day rate of the rig is just say 250k. We know that's not right, but if it was, say, 250 for ease of math, if that failure causes 2 days of unplanned downtime, the driller's exposure to the operator would be 2 times 250, 500k, which is more than 3 times the subcontract value. So a cap at that contract value, it doesn't even touch it. Once you do the math and you do the bird's eye view, it doesn't work. So you've got 3 types of 3 formula types that you look at. As I say, you got cap equals the contract value. It's simple to calculate and agree, but in high risk environments, it's almost always wrong. It provides a ceiling, yes, but it's below the foreseeable loss, and that's where the risk lies, in that that delta. So all you're really doing is you're giving a number, but not protection, if that makes sense. Then the second, you've got insurance proceeds, and this is probably the best practice for most subcontractors or subcontracts under the drilling contract. And that cap's then set at the proceeds of whatever the required insurance or the required contractual insurance. So that means that the ceiling reflects the service provider's actual financial capacity to respond. So both parties then understand what the ceiling is. The driller knows that the service provider has insurance backing whatever cap is there, and the service provider knows their exposure and what their limit is beyond any policy limits. As you say, unless there's a contractual obligation for a minimum insurance coverage, and the risk is higher, anything above the insurance is then essentially self-insured. That will come off your own bottom line as well. So one kind of important condition is that the formula only works if the insurance is properly maintained as well. So again, if it's linked to insurance proceeds, if the insurance policy hasn't been renewed during the course of the contract, then all you've got is a theoretical cap with no actual financial substance to it. My view, people asked to see the insurance documents. If you get your contracts manager or your contracts team asks to see the documents, if they don't review them properly, or if there's gaps, by not raising those gaps or disclosing or discovering what you have or what you haven't found, you're essentially accepting whatever they've given you, even if it's below what the contract says. So always be wary on whether you say you approve or disapprove of whatever insurance has been provided. There's still a contractual obligation to provide a certain minimum insurance. So I often would say I leave it with the service provider to manage themselves, unless I actually work for them. Yeah. So next there on the right, then you've got the cap equals the fixed sum. So that gives you commercial certainty, like your liquidated damages, to that extent that it's agreed in advance. It requires calibration. The fixed sum it's going to be proportionate to the risk. You've got more vision, more visibility on what it says and what's included. And you might annually review it on long-term contracts as well. So the fixed sum that was appropriate at the contract start may actually be wholly inadequate 3 years later, if the well program has expanded or there's some other fundamental change to the scope that you were brought in on. So insurance proceeds is often the better middle ground. So you have, even if you ask for a higher insurance limit, obviously the insurance premium will probably be passed on, but at least you know that there's solid cover there as well. Okay. Then we go to carve outs. So I kind of touched on it earlier, or said earlier, that a liability cap set at the start of the contracts is almost all wrong. Okay. So there is a worse situation, which is where you've got a liability cap with carve outs broad enough that capture basically every realistic scenario. So a cap that carves out negligence, breach of contract, breach of statutory duty, and you'll see this if we have time to do the case study, is almost functionally no cap at all. So always look at what your carve outs are, or what carve outs somebody tries to impose on you. You really have to map those out and scrutinize them. because let's if we kind of look through some kind of in turn, going from top left, death and personal injury. Yeah, accept that. That's non-negotiable under English law. Unfair Contracts Terms Act makes it statutory requirement that liability or for death or personal injury caused by negligence can't be excluded or limited. So that's usually there as a standard. So you can't negotiate that out. So you accept it, you ensure your insurance covers it enough, and you move on to the next one. You got fraud and dishonesty. Again, accept that. English courts will never enforce a cap on a party's own fraud, purely as a matter of public policy. So again, accept that there's no legitimate business that requires a cap on this, especially on fraudulent conduct. Then you got willful misconduct. So again, that should be negotiated. The principle of willful misconduct is fairly solid. It's a deliberate wrongdoing. So with that, it shouldn't be capped, and a party shouldn't benefit from the cap. And the risk is usually in the definitions as well, which should cover willful misconduct. I think off the top of my head the exact clause, but we can provide some clauses after. But it's sometimes defined to include recklessness or reckless indifference to consequence. And if the definition is too broad, the court would probably say it falls within the cap of any reasonable reading. So scrutinize that definition before you accept the carve out. You got gross negligence. Again, negotiate, but with a little bit of caution. Again, courts would not formally recognise that kind of distinct category of gross negligence. Some governing laws, say German and French, would have that distinguish or differentiation. And the phrase is quite uncertain then in English courts. So a carve out for gross negligence may be interpreted as very broad or very narrow. So wherever possible, define it precisely before accepting it, or resist the carve out and deal with the willful misconduct only. Again, usually with carve outs, most people would say hands down, okay, I accept, because you ask yourself, why is the carve out there? And usually the carve out's there because why would I be responsible for someone else's actions that they are in the prime position to mitigate themselves? Like jumping down to the breach of confidentiality, IP infringement, and so on. I can't control if somebody else talks. If the other side talk, why would I have that as a carve out? Or why would I not have that as a carve out, I should say? Or third party IP infringement. It's your IP. You should be giving me the warranties that it is protected and it's not infringing. So again, why would that not be included in the carve out? But anyway, digressing. So pollution and environment, again, there, negotiate that. It's often justified in principle, I'd say, but particularly for offshore, it's got to be limited to pollution caused by the party's own act or omission, and then aiming for a cap at like an insurable level. We all know the history of offshore oil spills and so on. And it needs to be matched by adequate environmental liability cover. So there needs to be specific coverage and insurance for that. Because an uncapped pollution indemnity without insurance backing is essentially for a small service provider, another existential risk, and a risk that can be managed, can be transferred by insurance. So it's making sure that those mitigations are in place. And on that insurance, some contracts carve out liability for breach of the insurance clause from the entire cap. And the logic for that is if you fail to maintain your insurance, you've removed the financial substance from the cap, so you should be uncapped. Again, that's quite disproportionate, because if the breach of insurance obligation has a proportionate remedy, then it shouldn't result in this unlimited liability. Deep. Then we got the IP infringement. Again, I'd say more often than not, oilfield subcontracts are not IP licensing agreements, unless there's like a cyber driller or something like that involved. So like statutory damages for IP infringement, again, can be disproportionate. So unless there's a genuine IP risk in a specific contract, either resist it or limit it to direct claims only. So try and make that as a quick win with a little bit of resistance. And then you have confidentiality, which it's assessing the contextuality of it. In a well data context, intentional confidential breach might merit a carve out, but inadvertent disclosure should remain within the cap. But also with confidentiality, it's very hard to prove unless it's in writing. And that's one thing you always have to kind of realize as well. Certain things you would challenge, certain things you would not challenge. And you have to look at the effort and the risk versus reward of how you challenge certain clauses, whether it's breach of confidentiality, whether it's a force majeure clause, and so on. You got to look at it with the contextual lens as well. Okay. Let's do a time check, 2:41. Okay, now we'll jump into the mechanics of the indemnity. So, how does that clause work technically? Okay, so again, another quite heavy slide. So the indemnity is a promise by one party, as we say at the top, the indemnifier to hold the other party, that's the indemnity, harmless against specified losses. Okay, so under English law, it's clearly drafted, and it's a powerful protection. So to explain why, you kind of got to run through the kind of 5 technical characteristics of the clause. So the first one would be the scope of protection. The scope of protected losses must be precisely defined. As I said earlier, you can throw they're responsible for everything except 1, 2, 3, 4, or they are responsible for 1, 2, 3, 4. One is everything but, and one is you're only liable for or indemnifying for. So indemnifying against all claims, losses, damages, costs, and expenses. We've seen these phrases time and time again. Each of these is a distinct category. Okay. And then claims, that then covers third-party claims brought against the indemnity. Losses covers direct financial loss. Costs covers expenses that will be incurred. And then specifically the addition of including reasonable legal fees. That's critical, because without it, the indemnity may win the claim, but be left with unrecovered legal costs. Historically, I had a claim that was about 2.5 million euros, and we worked out the cost to pursue that claim. It was a claim in Vietnam. The entity was in Holland, and the chosen court was Singapore. And to pursue that 2.5 million claim, it was going to cost, that wasn't going to be recoverable, given the Singaporean system. The unrecoverable cost for us to pursue 2.5 million was going to be about 800,000 euros. And the time that would take, given because it was cross-border, then you had enforcement, orders, and so on, and execution of the enforcement, it would take about 4 years. So by the time we looked at 800k, 4 years of time, effort, stress, disruption, employees flying to go to Singapore, Singapore courts required you to be there in person, rather from a witness perspective, rather than doing things online, etc. The disruption wasn't worth it, and we just dropped the claim, as the overall side was the client didn't want to have to worry about that risk. So again, looking at the costs of claims. So yeah, so without that, you can be left with a lot of unrecovered losses or unrecovered costs. So always include it, make sure it's in there. The second, we've got an indemnity is a primary obligation, not a secondary one. So this is important. It's an important technical distinction. So the indemnity obligation is primary. So the indemnifier steps in immediately upon the indemnity suffering the loss. So the indemnity doesn't need to first commence proceedings before experience the loss before claiming under the indemnity. It's not like a guarantee, which is a secondary obligation dependent on the primary debtor's failure per se. So you got to watch out for that indemnity clause. That it's qualified by upon final judgment, because that converts the primary obligation into a secondary, which it makes it significantly weaker. You're losing that ability to act immediately. You're delaying your ability to act. Then we've got the third. The third is the fault of the indemnity does not negate the obligation, but only if the clause says so, essentially. So again, under English law, if the indemnity can cover losses attributable to the indemnity's own negligence, but only if the clause expressly or clearly, but by necessary implication, extends that far. So what does the clause say? What is included? And the magic words here are notwithstanding any negligence, breach of duty, or act or omission of the driller group. Without that kind of express language, then courts could read down the indemnity, and they could exclude the indemnity's own contributory negligence. And that's probably one of the single most important drafting points in the indemnity clause, because again, it opens up the door for significant loss. Fourth, there we got notice and cooperation obligations. Again, most indemnity clauses require the indemnity to notify the indemnifier promptly when the claim arises. And there's times where people get into the nitty gritty of the word promptly and go, is it prompt? Is it immediate? Blah, blah, blah. One's prompt is what I used to always argue, because I was young and foolish, was promptly is a function of circumstance. Whereas immediate is irrespective of circumstance, you do it now. It's immediate. But yeah, so that allows the indemnifier to conduct the defence and not just kind of settle without the indemnifier's consent. So failure to comply with that can give the indemnifier grounds to reduce the payment. You didn't do it immediately. You didn't do it promptly. You didn't give me time. So as the indemnity, as the person receiving the indemnification, know your notice window and try and comply with it. Know what timelines. It kind of goes back to any contract. Understand your obligations. Understand your notice periods, your timelines, what you have to do by when, if there's any time bar provisions, etc., and try and act within them. So create that kind of contractual diary of what has to be done and when. And then if you're the indemnifier, you make sure the notice clause is workable. Because if it's an unrealistically short window, it can still be challenged in court. So it's a hard one to win. Then fifth and final, you've got the indemnity must survive termination, which we touched on before. And that's one of the most common, most serious drafting gaps in drilling subcontracts. Because the claims arriving from the incident during the contract period can be brought months or years after the contract's ended, depending on the statute of limitations. Whether it's a personal injury claim, or it's an environmental claim, or even property damage claims. If the termination clause, which is we're tying in the termination part, if the termination clause extinguishes all rights and obligations, and many do this, so be aware, then the indemnity no longer exists when the claim is brought. So always include a specific survival clause. And towards the end, I think I have a model clause for that as well. But that was a heavy one. As we get into indemnities, it does get quite meaty, so to say. So let's have a quick look here then at the model indemnity clause. This is a fairly well drafted one. It's not like I recall when we had 4 or 5 pages of indemnity clauses. There are times where indemnities are over engineered. There's times where they're under engineered. So it's trying to find that happy balance and making sure you have what you want to be included. That also allows for speed and agility in how you contract and how you negotiate, especially whenever there's a drilling contract on the horizon. You got to be pragmatic in how you draft, again, but having that understanding of what is and isn't included. So you can kind of dissect this component by component, but again, I want you to kind of like understand what every phrase in the clause actually does as well. So if you have, indemnify, defend, and hold harmless. Where my mouse is. There we go. Identify, defend, and hold harmless. Three verbs. Each of them does separate and distinct work. So indemnify means to compensate for the loss suffered. The defend means to take over the legal defence of any claim. So the indemnifier, funds and runs the litigation should it arise. Then hold harmless means to prevent the loss from being suffered in the first place. So that's like this anticipatory protection almost before the loss kind of crystallizes. So once you kind of take all three of those verbs together, they create the strongest available formula. So some contracts only use indemnify, which is obviously weaker when you look at the definitions. But all three together becomes the gold standard. And again, I don't know why people would not want to have all three, given the level of protection and scope that it gives. There you got the driller group. So the indemnity here in this case is the entire driller group. So we're saying it generically. Now, it's not just the contracting entity. So in this model clause, the service provider is indemnifying every company in the driller group. So you need to know how that group's defined. Goes back to your definitions. So if that includes the well operator, then the service provider is going to be indemnifying the operator without a direct contractual relationship with them. That's a big burden. That's a heavy weight in there. Then we got any and all claims, including reasonable legal fees. So the breadth of any and all, that's deliberate. That is your catch-all. And the specific inclusion of reasonable legal fees, as I said before, is critical. So without that, then the driller can win on substance and still be out of pocket for legal costs. So it's making sure that's captured, depending on which way you're going with the clause. So it's also the double-edged sword here of what you can try and request to be removed versus what you can request to be put in, depending on how the clause is drafted. And then you got notwithstanding any negligence, breach of duty, and other act or omission of any member of the driller group. So this is a key fault, kind of neutralizing language. It's expressly extending that cover to the driller group's own negligence. So without that phrase or something equivalent in effect, courts could interpret that or interpret the indemnity as not extending to losses caused by the indemnity's own conduct. So in the context of oil field contracting, incidents do frequently involve concurrent negligence. There could be two parties. So the service provider's equipment failure and the driller's operational response could both contribute to the loss. So without that language, the indemnity may fall exactly on facts and on the fact it was designed to cover. So making sure you map out, you kind of simulate what that loss could essentially be. Again, you guys will get these slides sent out after the session as well. So here we got the mutual hold harmless regime, which is very common in the North Sea. So we'll look just briefly at how it's engineered, where it breaks, how it works. So under the UK CS oilfield contracting, they define this feature. So obviously, if you work in the North Sea on either side, driller or the service provider relationship, you'll encounter this in every contract. So you should be fairly familiar with them. So it's basically built on 4 interlocking indemnity obligations within it. Each one is essential. So if you remove one or weaken any of them, the whole structure gets compromised. It's back to having your what was your foundation, and then you have your building blocks on top of it. So when you put the building blocks, the structure could collapse. So obligation A is each party indemnifies the other against personal injury or death of its own group members. That's the bury your own position. So here the driller takes responsibility for the driller group's personnel. The service provider takes responsibility for the service group's provider. And if a driller employee is injured and sues the service provider, alleging, for example, service provider's equipment was defective, well, the driller holds the service provider harmless. So it doesn't matter whether the service provider was actually negligent or not. The allocation of the risk is based on the group's membership, not fault. So this is this like fault neutral principle that we spoke about before that makes the mutual hold harmless regime and structure work. And it reduces litigation. It makes things very, very clear. It's clear from the get-go who's responsible for what. But without it, then every injury to the driller employee in an operation involving the service provider's equipment is a potential claim. So keep that in mind. The obligation B, where each party indemnifies the other against loss or damage to its own property. So again, here the driller insures the driller's property. Service provider insures the service provider's property. And if the driller's negligence destroys the service provider's, say, downhole tools, service provider can't bring a claim against the driller. So the service provider holds the driller harmless. So again, each party self-insures its own assets, is what we're basically saying in this context. So both parties then focus on maintaining adequate, proper insurance rather than litigating, every fault after an incident. Okay. And then you got obligation C, which is consequential loss exclusion. So neither party is liable to the other for whatever the defined categories of consequential loss are. And again, as I said at the start, the catastrophic scale of losses, whether it's production revenue, lost profit, reservoir damage, these are all removed from that liability picture entirely. So it's something that is just removed from both parties. And that's why you need to have that consistency between whatever your main contract is and your subcontract is from a consequential loss perspective. So you got to make sure those definitions are clear, are so important. And if categories differ in the main contract and the subcontract or the service provider contract, if there's gaps there, that's where you're going to get exposed. So again, map those exposures and plug them. Then you got obligation D, which is the where the regime operates regardless of fault, negligence, or strict liability. So this is the engine almost of the entire system, where the mutual hold harmless doesn't ask whose fault it was. It allocates by group. So this basically eliminates the majority of any fault attribution disputes between the two parties, and both parties can focus on their operations. I think that's one of the main things. You want to try and go in, get the job done, and be done without worrying about it, rather than building legal cases. As I said there, 4 years of legal work at substantial cost. So rather than have to deal with that, focus on the operations and then not have to worry about building legal cases against each other, which just destroys relationships as well. So here, this is where the mutual hold harmless breaks. There's six ways that it fails in practice, and each one is quite specific, but it's also preventable if you spend a bit of time on it. So the first one there is the group definition is too narrow, fairly obvious. Service provider group means the service provider company only. The service provider's employees work on the rig every day. Okay, they're there. They're not within this service provider group as defined. Then you have the driller group. The driller group employee, say he's injured by the service provider and sues the service provider. The service provider can't hold the driller harmless because the injured person's, he's not in either group. So the indemnity then doesn't respond. And if it doesn't respond, then there's no coverage, which then causes more disputes. So again, the fix there, have a broad definition. Company, parent, affiliates, officers, employees, agents, subcontractors, blah, 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 blah. Include everyone and their dog where possible. And then we got we have two asymmetric groups. So the drilling group includes the well operator and its affiliates, but the service provider group only covers the service provider and its employees. So the service provider is indemnifying a group of potentially 50 companies, whereas the driller is indemnifying a much smaller group. So there's that mass imbalance, and it's a balance of the mutual hold harmless there that's then broken, because it's mutual, yes, but it is grossly disproportionate. So again, The fix there is to ensure the service provider's own group is equally as broad, or limit the service provider's indemnities to the driller alone and not extend those to the operator group. So there's kind of different ways to skin a cat per se. Then we have gross negligence carve-outs. Carve out things that are undefined or too broad. So the mutual hold harmless kind of falls away from gross negligence, and that's standard. But if gross negligence isn't defined, or it's defined so broadly that it captures like ordinary professional negligence, then the carve-out renders the entire regime uncertain. So every incident would give the claiming party grounds to argue gross negligence and step outside the regime or the structure. So again, the fix there, which we do see a lot in master service agreements, would be a definition of gross negligence, and usually it comes in as a conscious or voluntary act or omission of reckless disregard for foreseeable consequence. That's a pretty solid catch-all, and it does also set a fairly high threshold as well. Then the fourth there, we got consequential loss definition, narrower than the main contract, which we've touched on. So if the main contract excludes loss of production and the subcontract consequential loss clause omits that category, then the service provider breach that causes loss production, it's not excluded under the subcontract. So the driller then has a direct claim against the service provider for production loss. So make sure like both documents, where possible, are reviewed side by side, and obviously try and do things back to back or mirror at least to the greatest extent possible the definitions. Okay. Fifth there is no survival clause. So again, personal injury, property damage, they're routinely brought years after the incident occurred. So if the termination clause extinguishes all the rights and obligations, and the indemnity has no survival clause, then you start to see the knock-on effect and how it all pieces together. The mutual hold harmless then ceases to exist at termination. It dies, it extinguishes, it's gone. So then claims for incidents during the contract are unindemnified. So the fix there, fairly straight, is express survival clause naming the indemnity provisions. Even just the clause number, whatever the way the clause is drafted, get it in there. And then sixth there, you've got the two mutual hold harmless regimes aren't cross-referenced. So the main contract and subcontract use different group definitions, different carve-outs, different structures, and both are technically valid regimes, but they don't fit together. You got a puzzle with pieces that don't connect correctly. If they don't connect correctly, then at the seam there's going to be gaps. There's going to be claims. You could have the supplier or the service provider claiming against the operator, passing it through to the driller, and then there's gaps that neither contract covers. So I think then there the main point is that state expressly in the subcontract that the mutual hold harmless is intended to be consistent with, or at least complementary to, the main contract mutual hold harmless structure. Try and connect them and try and make sure there's no gaps in the drafting and in the coverage. What lawyers end up getting paid for. So termination. With termination, then there's 4 grounds for termination we're going to cover, and each has different financial consequences. So you got termination for convenience. This is probably the driller's most powerful tool commercially, and it's the service provider's greatest single commercial risk, in my view. The driller can exit for any reason with short notice. It is horrible. The recovery there is, work done, direct demob costs, lost profit on the remaining term is excluded, unless it's specifically negotiated as well. So areas to look for. And I kind of two points to kind of note here on the termination for convenience is, firstly, that it's a legitimate commercial right. That's the thing. Programs will change. Wells might have unexpected problems. Operators might have to redirect resources and so on. So the driller needs to have an exit. Don't go into a room or a building without knowing where the exit is. And the second is that the service provider is he's probably mobilized quite expensively, and potentially committed long-term subcontracts and equipment hire and so on. They've committed a lot of cost towards this. So when you get a 7-day notice period on a 6-month program, it's going to be commercially devastating, without having the proper recovery provisions. So both sides need to make sure that they treat this clause as a commercial negotiation and not as an afterthought. Then you got termination for default. It's medium risk. It's available for either party. Well, obviously, the triggers are going to be your material breach, failure to cure within the cure period, insolvency, and also persistent breach. And here, I'd say the key word is going to be material. So minor or technical breaches don't typically justify termination. And then you obviously got to look at the procedure. What is the procedure for termination? You've got your breach notice, then your cure period, and then your termination notice. If you miss any of those steps, then you got a procedural defect. So even in the drafting of those steps, it's understanding what is a fair and reasonable time for those certain aspects or times or whatever to actually occur. Then you got termination for insolvency. So with the termination for insolvency, that's going to be triggered automatically, or at least on notice by a series of events that would occur by statute. So you have like your administration, liquidation, the receiver appointment. It might be a voluntary arrangement. Then you have your standard accounting / finance positions. So for the service provider, if it's insolvency of the driller, that means a claim as an unsecured debtor in insolvency. So that's typically very low recovery. And then you look at retention of provisions that can protect the equipment that's on the rig or on site, and make sure they're not treated as driller assets as well. So making sure nameplates, asset registers, etc., are maintained. Then you got termination for force majeure. So again, where the force majeure event comes beyond a defined period, that's typically 30 to 90 days. Either party can terminate. And recovery for both parties is limited usually to work done and direct costs. But then the key issues here again, how is force majeure defined, and whether the procedure has been followed correctly as well. And one thing I always point out on force majeure is that the threshold is very, very high. The burden of proof, looking at causation, and so on and so forth, it's a big task and it's very difficult. I had one case. It was a factory in Chile, and in that factory there was a fire, which then affected the manufacturing of some equipment. So the supplier claimed force majeure. We rejected it once we got into the nuts and bolts of it. The fire was caused by a distribution panel. The distribution panel hadn't been maintained, so it was reasonable to foresee that had that distribution panel been maintained and managed, the fire wouldn't have occurred. So it wasn't force majeure, it was the manufacturer's negligence. So you look at things with a different lens when you're trying to get out of it. Okay, so here now we'll just look then at termination procedure. And again, just to be kind of direct, I'll check on time again, we're 10 past. Be kind of direct about why this matters. A contractual termination right exercised incorrectly is going to be a wrongful termination. So you got to make sure that when you do it, when you pull the trigger, it aligns with whatever strategy that you have, and you've got all your ducks in a row to make sure that you do it right. Because there's nothing worse than going in, handing over the termination notice, and all of a sudden realizing that you've misread or you've done something incorrect as far as procedural, and then you get a procedural fault, which then leads to wrongful termination and a counterclaim against you. So if you terminate without the procedure of say wrong notice period, wrong form, premature execution, even before the cure period expires, it becomes a repudiatory breach, which you'll be liable for. So the other party could accept that the breach and claim damages. That it could include lost profit from their side. It could be lost profit for the remainder of the contract. And if a driller wrongfully terminates the service provider post mobilization, they may face damages that exceed the original contract value. So again, you really have to do your homework from a mathematical perspective, commercial perspective, procedural perspective, and so on, to make sure that once you pull that trigger, the genie is going to be tough to get back into the bottle. Is the polite way of saying it. So you usually got a 5-step procedure for termination for default. I got them 5 steps there. You got the first, that's the identity. Identify the breach. Is it a genuine breach? Is it a material breach? Is it minor or technical? Can you fix it? Read the contract's definition of material and understand it. And if it's undefined, apply the appropriate standard. Do a bit of legal research. What does the law say in that jurisdiction, and so on. Don't make assumptions. Step 2, serve the notice. Obviously, yep, in writing. You got to comply with the notices clause, the correct form, the correct address, the correct method. There's times where I've received court notices from, say, Dubai courts after the execution order has been issued by the judge on a case I didn't even know existed. That was because the notice was sent correctly. It's just that we had the wrong email address, the wrong phone number of a colleague was in the system. So it wasn't our fault. It was that the system had migrated, and there were some human error issues. But we never got the notice, and the court case proceeded without our knowledge, and we lost because we were not there to defend. So we got to make sure what the notice clause says, what has to be done, and make sure the whole communication chain is intact. And again, state that the breach itself is specifically what the breach is and what the remedy required is. Here's what you've done. Here's what we would need you to do to fix it. If it's a vague notice, it could be a defective notice, which might not require any, or wouldn't require any action on the other party. Third step is allowing the cure period. Again, the party in breach has, the breach must have been a genuine workable opportunity to rectify or remedy. They must have the opportunity to fix it if it's fixable. And if the contract says 14 days and you have to allow the full 14 days, whether calendar, business, Gregorian, whatever it may be, whatever the definition is, you must allow that full period before taking any next steps. So if it's not expired, you can't terminate. It's that simple. It's a contractual right to have that time period. Fourth step is assess the cure. So has the breach been remedied? If it has, then the termination rights lapsed unless it reoccurs. If it hasn't, then you can go on to the next step, which is the serving of the termination notice. So again, in writing, compliant with the clause, stating the grounds specifically. It could just be a simple table where you're saying, here's where you've breached, here's what we want, here's our loss, bum, bum, bum. It doesn't need to be a Shakespearean work of art. It could be something very, very simple. But as long as it's structured correctly, it's clear, it's concise, it's got the effective date, it's got the statement, and it's very important to have this in all kind of communications where there's a claim involved, is making sure that you have the reservation of rights. That preserves any accrued right that you may have under the contract. Without it, you could lose access and rights to previous claims. Okay. Now just on the right hand side there we got the accrued rights on the wrongful termination, which we've touched on. So again, accrued rights, so the termination doesn't extinguish rights that have already been accrued. So payment for work done is right, claims for breach that have already occurred, indemnities where there's a survival clause, it maintains those rights irrespective of what happens with that specific claim. So be careful what you say when it comes to claims. Be careful what communications you have. By all means, yes, you can have communications with the counterparty, just not about the specific claim unless you preserve your position and protect your rights. And these accrued rights should survive unless the contract expressly says it doesn't. So again, back to your drafting. So you have to know what your survival clause has for indemnities specifically. And that's a wrongful termination. But the consequence there of wrongful termination is that the innocent party could accept the breach and then claim damages. So again, be wary, be cautious of what your contract says. It's not just a piece of paper. We're getting close to the end here. Again, aware of time. The termination recovery mechanics. So what you recover on termination and basically how to protect it in the clause. So we just do a quick kind of walk through the table. So from the top down, you got work done to date. That's typically included, but agreed rates and not uplifted rates. So best practice would be all amounts in the contract rates plus verified additional works, etc. From the driller side, it's going to be again agreed rates only, no uplift, and so on. Your demob costs, which are typically covering direct costs only, and that often means transport back to shore, personnel travel. It's going to probably exclude the cost of unwinding your subcontracts and standing down hired equipment, off-hire costs, etc. And any administrative costs to close your operations for that specific job or that specific site. Again, best practice, all reasonable demob costs, including logistics and even standby during demob period as well. You want to try and get your money back. You got committed expenditure. Again, that's typically excluded because if the service providers place advanced orders for, say, consumables, or they've committed to personnel contracts or even specialist equipment on the strength of that contract, that commitment is usually unrecoverable for the typical convenience termination. So again, pre-committed costs should be those that are reasonably incurred, or costs that you can reallocate or redistribute, or if you find someone else who's willing to take it on for a new project that might come up, should try and be recoverable. And then from the driller side, you've got your the service providers have an obligation to mitigate those costs, so they have to cancel what can be cancelled. Don't just sit on it and say, well, they're going to cover it. So make sure what can be cancelled can be cancelled. You got lost profit on the remaining term as well. So again, that's almost universally excluded in unamended contracts. So for the service provider, this is probably the single largest gap in termination recovery. A 6-month program terminated on month 2, and the service providers lost probably 4 months of profit, and that becomes an issue depending on when the financial reporting period is, where they may have put provisions in it and recognize that revenue, which then becomes an issue from an accounting perspective. So again, they should be including a cancellation fee, usually as like a percentage of the estimated value of unperformed services. It's one way to look at it. And it becomes, again, a pre-estimate of lost profit. It becomes a negotiation point, as with most things anyway. And that's usually 15-25%. And then finally there, you've got the equipment return and demurrage. So that's often consistently mishandled or consistently inconsistently handled. All equipment returned at the driller's cost is usually the standard case, and then you get any waiting time or demurrage costs. From a best practice perspective, the driller's obviously going to look for he wants to fix that logistics return schedule, and he wants to cap the costs. So clarity on these things and expectations. What do you want? What's your walk away? What do you need to recover? And so on. It'll all come down to reasonableness and say commercial negotiation. Right. Now we got some drafting for protection. I'll try and go through this quickly, aware of time. There we go. So here you've basically got 8 rules, and these are going to be the principles that I personally kind of apply to drafting that I do, or when I review liability, indemnity clauses, or termination clauses. So first, specificity beats generality. So a specific inclusion or exclusion is harder to attack than a general one. So again, name every category of loss that you intend to exclude. and don't just rely on that indirect or consequential. Name the production losses. It depends on time and who the counterparty is, because the opposite would be, again, doing a catch-all and doing the opposite and saying what they are included for. It depends which side you're fighting for. But obviously always try and be generic, giving it to the other side that they're responsible for everything, excluding 1, 2, 3, 4, rather than they're only including 1, 2, 3, 4 to cover the catch-all. Secondly, there, if you want indemnity to cover the indemnity's own negligence, say so. Be clear. Say what you want. Because whenever the contract's going to be reviewed, it'll be reviewed in vaguely the context, but also from the four corners of the document. What does the document say? So again, if it's not in, it's out. Is the crux of that one. Thirdly, there, define terms within the clause. So don't rely on the definition section being read correctly in isolation. You've got to review the contract like we did in the last session. The contract has to be viewed holistically. Map it out. For a critical indemnity, consider restating the group definition within the clause body, but make sure it's consistent with the definition that's drafted. Don't start, trying to draft things differently from the main part, because it'll lead to ambiguity and confusion, which leads to disputes. Always include a survival clause. I have seen many contracts without, or with a very, very lax one. And basically, you have to state explicitly that the indemnity survives termination. For a defined period, at a minimum, it should be the applicable limitation period. Maybe aim for like 6 years on a simple contract. 12 years for contracts that are executed as deeds. Those are a bit more severe. Every carve out from a liability cap, it's got to be defined, and it's got to define the threshold precisely. So gross negligence without that definition that we discussed is just going to be an open-ended carve out that could just swallow the entire cap. So whenever you draft caps, understand what the draft is, what the exclusions are, what the impact is, and whether it's realistic. Sixth, there we've got aligning recovery with the actual exposure. The contract value is not the right cap for formula for a high risk contract. So aiming for the insurance proceeds as a preferred route. And also take the condition that the insurance has been properly maintained, and it's got to be included in there as well. Otherwise, you've got words with no structure, no protection. Seventh, there we've got make the termination procedure workable. Again, cure periods must be, they've got to be long enough and realistic enough. Don't give someone 12 hours to remedy something that will take a lot longer. It's got to be relative to the actual breach in context. So again, technical failure that can't be remedied in 7 days, it's just not workable. And the court would also find that same. And then once the court looks at you with that you're trying to screw them eyes, he's going to question everything else that you've done as well. It casts a real kind of disparagement on your actions as a whole. Because again, from an equitable stance, making sure you have clean hands and you've done everything to the best of your ability. And then eighth, there you got the cross-reference between the subcontract and the main contract, including an express statement that the subcontract hold harmless is consistent through that main contract regime, and it flows down correctly into the subcontracts and so on as well. It doesn't resolve definition differences, but at least it establishes that interpretive framework that you have to work within. Okay. Okay. There we go. All right. So here we're just going to look, the three kind of before and after examples that we've pulled together. I'll go through each one quite quickly. So I want you guys obviously to read both versions and understand specifically the improved version and what the improved version achieves. So you go from the simplistic version, back of a napkin version on the left, to a little bit more meat on it on the right. So before, with the liability cap, total liability of the contractor on this agreement shall not exceed the contract value. So again, before it equals the contract value, there's no carve outs, there's no reference to insurance. And as we've discussed, it's a cap at contract value. It's almost certainly below the foreseeable loss on a rig operation. And then you got the clause provides the appearance of a cap without substance as well. So we don't know exactly what that cap is. Where's the substance behind it? Looking to the right, we've now got a cap that equals insurance proceeds. We got a cap that provides insurance that has to be properly maintained. And this kind of formulation does a few things for us. It aligns the cap with the actual financial capacity that the service provider has via mitigation from insurance, and it creates this incentive for the service provider to maintain that insurance and removes any uncertainty about whether that cap will bite and will be triggered. So you got a significant shift in the coverage there. The mutual hold harmless, the group definition. Before we say the contractor group means the contractor, full stop. So 2 words there. It's one company. Contractor group means the contractor. That's going to be one company. So the entire mutual hold harmless structure rests on a group definition that excludes everyone who matters operationally. It's just the contractor, no one else. Not your catering provider, not your cementer, not any rig hands, whatever, third-party labor, nothing. So once you add that comprehensive group definition on the right-hand side, then you got company, parents, subsidiaries, affiliates at every tier. Obviously, you'll get into the definition of affiliates. Officers, directors, employees, agents, subcontractors at every tier, and personnel of each. So every person on that rig performing service provider work is within that definition. You've got a good solid catch-all, and then that mutual hold harmless extends and protects everyone. And finally, you got the termination for convenience. So before we say Julie may terminate this agreement for convenience on 7 days, written notice on termination, the driller shall pay the service provider for work done prior to the termination date. So 7 days notice is what they've got. You got recovery just for work done, and all 4 of the kind of key recovery heads are missing. Sorry for the right hand side is a bit squished, but there, after 30 days, we've added 30 days of minimum notice on the right hand side. We've added those 4 distinct recovery heads. We got through, and specifically subclause D is cancellation fee, expressed as a percentage of the estimated value of unperformed services. That will probably be negotiated out from a commercial perspective, but at least it's in there as a baseline. So both parties agree up front that lost profit compensation, they know what it looks like, and they've expressed this genuine pre-estimate. So it's harder to challenge if it remains and it ever gets pushed in court. And there's no open-ended damage claims. So that then creates that certainty for both sides. Okay. So again, aware of time. That's pretty much us. What I'll do is I'll share the case study because that will take a little bit of time for everyone to go through, maybe 20 minutes or so. But it gives you just an indication to kind of test your knowledge. So go through that slide first. I think it's slide number 25. And then you got the answers on slide 26. So I'm not going to get into that for you. You can do it yourselves. And then there's 6, basically, we're going to have 6 takeaways to try and close off with the recap. So first, liability, indemnity, and termination. It's a system, and then a gap in any one will undermine the whole protection provided by the others. It works both ways. It can work to your advantage or disadvantage, but at least be aware, review them together, and don't review them in isolation. Secondary, you got the liability cap. That's only as good as what it excludes. That's the crux of it. Carve outs for negligence, breach of contract, or statutory breach of duty. It makes that cap largely meaningless. And then caps that equal insurance proceeds are probably the best practice. It's going to be a chicken and egg perspective, potentially, depending on how much insurance you have. You might try and put the insurance that you have in as your cap rather than increase your premiums, but it becomes a commercial negotiation in those discussions. Thirdly, the indemnity requires specific language to cover the indemnity's own negligence. So without the whole notwithstanding any negligence of the party, the courts would read it down and name the fault neutral extension. So be aware of that. Fourthly, there we got the mutual hold harmless, the 6 predictable ways we look at it. You got the group definitions being too narrow, the asymmetric groups. You've got the undefined gross negligence, etc., etc. So make sure you check all 6. Make sure that you're covered. There's no gaps there. You don't want to have that delta coming in and destroying the bottom line. Fifth, there we got termination procedure. Again, you don't want to have any issues with procedural default, so to say, that could then affect the termination, which results in wrongful termination, which then results in a counterclaim against you. So again, proper planning prevents poor performance. And then 6th, there you got recovery on termination must be drafted, not assumed. So make sure you're clear commercially on the recovery heads, what you're going to get back at the end. And at the end, that is us. We probably have a few minutes for discussions or for any questions. I see some people are dropping off as well. What we can do, there's my contact details. It'll be on the slides anyway as well. There's the link to ARC and for Outhouse. So if you have any deep, meaningful questions, obviously you get a lot of questions linked then to confidentiality and so on in the existing contracts that you have. But you can see that these topics, I've spoken there for an hour and a half on just three clauses at a very high level without getting into the intricacies of specific drafting. If you have any clauses that need reviewed or you guys want a second eye on or want to look at things in more context, again, by all means, open to hear, listen, understand, guide, etc. And then we'll probably have our next training session next month, which I cannot remember what the topic is, but it'll be another good one as well. Okay, so everyone, again, thanks a lot, much appreciated. So if you have any questions, I don't think there's many questions on the chat right now. So if you have any questions, drop me an email or drop the work group email a few questions as well. Okay, so again, thanks, and we'll speak next time.